So first I'll take the obligatory moment to fumble around with my papers. Let me start by thanking all of you for hearing me out. Let me thank Capital Forum for putting this event together and for giving me the opportunity to speak. And let me also give the disclaimer that we always give, which is the views I express are at most only my own and not necessarily the views of the Federal Trade Commission or any commissioner. And I wanted to also start, this is a technology-focused event. Some of you, especially those of you who've had the misfortune of hearing me speak before, may have noticed that I sound different or worse or like I have a cold. It's because I do. And so to the tech companies out there, please take some energy away from striving for world domination and get rid of the common cold. I'd really appreciate it. It would be a good use of your time. But actually on that note, I'm going to talk about, and to some extent, I'm going to focus on the FTC hearings today and the technology space and some aspects of the hearings that relate to the technology space. But I wanted to start by talking about a bit of historical, technological and sociological historical context. I want everybody to think about a period in American history where there was a radical change in technology in the country that transformed the economy, transformed how people worked, created enormous improvements in daily life, but caused huge disruptions, including putting a lot of people out of work, and also where immigration was a hot-button issue and there was a growing divide between rural and urban America. Might sound a little familiar, but I'm actually talking about the period post-Reconstruction after the Civil War from 1877 to the early 20th century, where all of those same phenomena existed. It was a huge change from an agricultural economy to a largely rural economy to an industrialized and urban economy. And a question that came up at that time was, how should the government respond to preserve and enhance the benefits of technological progress while addressing the social ills and discontents and dislocation that arose as a consequence of those changes? What should the government do if the economy reinvents itself? What's the appropriate line between free markets and regulation? And one answer at that time was the Sherman Act of 1890. So let's fast forward about 100 years. 100 years later, antitrust was maybe a villain in a very similar narrative, or at best what you might call a befuddled bystander. And I'm going to quote a leading antitrust enforcer from a century after what I described a minute ago. The quote is, "Some question whether the existing antitrust laws can possibly be relevant to today's economy. The Sherman Act was passed in 1890 in response to the nationwide industrial trusts that the railroads had made possible. And the Clayton Act was passed in 1914 and was aimed largely at retailing and wholesaling practices in localized markets. How then can these ancient statutes be relevant to a 21st century information-based economy?" That, of course, was then Assistant Attorney General Joel Klein speaking 20 years ago in 1998, addressing nationwide angst about the insufficient response of antitrust enforcement against the tech giants who were AOL, Netscape, at one point the largest internet company in the world, Microsoft, Intel, HP, Dell, and Compaq, among others. Now I want to skip to the end, which is a vague movie allusion for those of you who get it, or to today, 20 years later, 2018. So today we have a very similar situation with actually a startlingly similar critique and a startlingly similar narrative playing out in the discussion of technology and antitrust. We have a radically changing economy. We have a dizzying rate of technological change, and in many respects, you could analogize the vastly more efficient communications and transportations networks that we have today, where you can have instantaneous communication and almost instantaneous sales, extremely rapid delivery, to the effect the railroads had on the previously very slow-moving economy and highly localized economy. We have new titans that have arisen in businesses that would not even have been imaginable, like online search, social networking, electronic retail. And against all that, we have claims of lax antitrust enforcement, not just at the margins and not just in straightforward applications of antitrust law and concepts, but in foundational principles of antitrust that have been called into question and criticized for failing to arrest or to restrain these changes. And particularly of relevance, I think, to this conference is the intersection between antitrust and today's AOLs, Netscapes, and Microsofts, Amazon, Google, and Facebook, and firms like them. Now, I talked a minute ago about challenges to foundational principles of antitrust, and there I'm referring largely to about a 40-year consensus on antitrust enforcement. And I want to note, as Chairman Simons and others from the Commission, Commissioner Chopra and others have repeatedly noted, that the fact that everybody's done something a certain way for a long time does not necessarily mean that that's the right way, or that we should keep doing things that way forever. In the face of changes, it's fair to consider facts and proposals with an open mind. And in fact, one of the aspects of antitrust that I think has rendered it valid and effective over more than a century, and this is something I've spoken about before, is that antitrust itself is very broad and prescriptive as opposed to being very specific. And so antitrust has been able to evolve with changes in learning and changes in circumstances. This is why Chairman Simons launched the FTC hearings, Competition and Consumer Protection in the 21st Century, that were mentioned before. The basic concept is to help develop the factual and theoretical framework necessary to fully assess these issues that I talked about and to provide a sound basis for policy going forward. So in the rest of what I'm going to say today, in the whatever amount of time I've got, I'm going to talk about the issues, more specifically about the issues that underlie the hearings with specific reference to technology, on the progress of the hearings to date, and give you some thoughts on what we've been learning in the hearings and how that might have some effects on how we think about enforcement and other issues going forward. I want to be clear that we're not done. The hearings are not finished, and there's a lot of assessment to do afterwards. The body of information they produce is already quite substantial. So this is very much a work in progress, but I think it'd be fair to say that we're learning and hearing a lot of interesting things. So let me start with why have hearings? And I think it's important to remember that this is not a routine thing. The FTC does lots of hearings. It's part of what you might refer to as, what has been referred to as the cultural DNA of the FTC specifically, is that it views one of its primary missions as being contributing to the intellectual and factual underpinnings of antitrust policy in almost a think tank kind of way or a research and development kind of way. So we do a lot of hearings, but we don't routinely do multiple sessions of hearings on broad topics. It's really only been done once before under Chairman Potofsky back in the 1990s at a somewhat similar time of massive technological change in the United States economy. So when Chairman Simons came in, as you point out, along with our 4 other brand new commissioners in this last calendar year, which has not happened since 1914, he looked at the circumstances and he thought this is a good opportunity to do exactly that same kind of thing, to do an antitrust reboot, if you like, in the face of the changes in the economy and the questions about the fundamental roles of antitrust. Now, when I think about the hearings and what we're trying to do with them, to me, you can kind of boil it down into 3 big questions. The first question is there a problem? And by that I mean, is there actually an economic, social, or legal problem that's within the broad range of concerns that antitrust enforcers have both expertise and a statutory mandate to address? And if so, what is the extent of that problem? By problem, I don't mean a singular or unitary phenomenon. It could be lots of problems. But I think first and foremost, there can be lots of media discussion about problems, but until you actually delve into the facts, it's unclear whether that's a real issue or whether there really are significant problems that ought to be addressed. The second question is, to the extent that we identify problems, what role did antitrust enforcement or lack of enforcement play in creating or continuing or exacerbating those problems? Because there are lots of problems, there's lots of social ills that exist that may have nothing whatsoever to do with competition policy. Antitrust is not a panacea for everything that may be wrong in the world. I am not a guru of fixing all problems that everybody might have. I mean, sometimes I think I am, or I'm accused by others of saying that I am. But the fact of the matter is that we have specific expertise. We have specific things that we're asked to do. Antitrust or competition policy in general has a specific realm in which it operates. Now, you can talk about what is the appropriate scope of that realm, but I don't think anybody would say the appropriate world for competition enforcers would be to dictate down to the last detail every aspect of our economies or our societies or anything else. There's a role for antitrust, and if there's a problem, the question is there a problem within that mandate? And that leads to my third big organizing question about hearings. The third question you might want to answer in this kind of exercise is, if there are problems, and also to the extent antitrust contributed to them, how can antitrust help solve them? Is it changes around the margins? Is it larger changes? Is it things that we have missed that we should do better? There's a lot of issues there that could be explored to determine the appropriate scope for intervention, for activity, for changes. So let me talk a little bit more about these questions before I go to the hearings themselves. The first question I asked is there a problem? Now, at a broad level, what you read about and what people point to is evidence of increased concentration in the US economy, and by the way, in the global economy, at very high levels of definition, like two industry NAICS codes. So if you look, that would mean, for example, in the US, you would look at retail across the entire country would be an industry at that level. There is evidence that there have been increases in what are called markups, evidence that there is an increase in corporate profits, evidence of reduced productivity growth, declines in startups, and of course, a lot of evidence of rising economic inequality. Now, specifically with regard to the technology space, I think the problem that you read about, the argument that there's a problem, to a large extent, revolves around the possession of large shares for a long time by a few companies in the spaces they occupy. Google, Alphabet, and search, and maybe search advertising, Facebook and social media, Amazon and electronic retail. Some people throw in Apple, Netflix, Microsoft. There's all kinds of various permutations of acronyms like FANG and so forth, or FANGMA and things like that. But you can certainly say there are a set of companies that have had pretty large shares, some in the 90+% range, in spaces like online search for a pretty long period of time. The second question is antitrust to blame? And a lot of people say yes. And I'll read you a quote from a recent op-ed in the New York Times, which is typically understated. Quote, "The federal government, under presidents of both parties, has largely surrendered to monopoly power. Washington allows most mega mergers to proceed either straight up or with only fig leaf changes. The government has also done nothing to prevent the emergence of dominant new technology companies that mimic the old AT&T monopoly. This meekness has made possible the consolidation of one industry after another." And this is a very common view. The argument is that antitrust has failed to stop mergers, especially failed to stop nascent mergers or acquisitions of small firms, that antitrust enforcers have failed to bring conduct cases, and frankly, some of it is looking at results. How can it be that we have really large firms that have been large for a relatively long time, like a decade, without antitrust having done something about it? And then the last question, a little more refinement on the last question, can antitrust solve it? A lot of people say yes, and they propose a lot of different ideas, like tightening merger policy around the margins, or doing larger things to merger policy, like reversing the burden of proof and making merging firms prove that they ought to be allowed to merge, or outright prohibiting large firms from buying small firms or large technology firms from buying small technology firms, or prohibiting any acquisitions. I heard in Europe last week a proposal that we prohibit large successful firms from growing organically because they're obviously so good at what they do that they shouldn't be allowed to enter new spaces because they'll be really good competitors in those spaces, and that should be stopped. There have been proposals for changing the standards for conduct cases, many other proposals. So with all that, let me turn to what's happening at the hearings in our attempt to answer some of these questions in the refined way that they were posed. First of all, I want to underscore again, the hearings are still in progress. We've had 8 hearings to date. There are at least 2 more sets of hearings scheduled, and there may be another couple after that. And by hearings, I mean events which are typically multi-day events with multiple panels, multiple speakers, plus we have been inviting and receiving a large number of written submissions from stakeholders and interested parties across the world, frankly, giving us views, all of which are extremely helpful. And parenthetically, to the extent anybody out here is interested in doing so, I would invite you to please submit. In connection with the questions I posed, the first question is something wrong? Is there a problem? At least 3 hearings address that issue with multiple panels and have produced a huge written record on this question. To the second question, is antitrust to blame for the problems that I described a minute ago? We've had at least 6 hearings out of the 8 that covered that issue in part. Now, by the way, the reason I'm slightly imprecise about this is because a lot of these hearings had multiple topics in them, and so you could assign my question to one topic or another, depending on matters of definition. I don't intend to be so precise. I'm just being directional here. But at least 6 of these hearings have touched in some detail on the question of whether antitrust enforcement policy is to blame for these issues. And what could be done with antitrust to address them? At least 5 of the hearings we've held have involved attempting to answer that question. So what are we hearing at the hearings? Well, again, this is very preliminary, but I want to provide some points that we have found, that I have found interesting And I'm only going to talk about points that I think are relevant to technology specifically, as opposed to some of the other issues, which are actually many. There's a lot of things in these hearings beyond the technology space. First, insofar as is there a problem, I think one thing that we have heard is there's not a consensus that there is a problem with concentration specifically in the economy. And let me give you an example as to why. And this really, to a great extent, has to do with measurement. So I talked earlier about concentration being measured at two-digit NAICS codes levels like restaurants or retail. When you think about nationwide restaurant concentration, in terms of competition, it's not clear how relevant that issue is. When I leave here tonight and I go looking for somewhere to eat, I'm not very likely to go to Memphis or New York or someplace like that to get dinner. I'm very likely to go somewhere really close here. And so the relevant competitive market for me when I'm looking for restaurant choices consists of the set of places to which I could walk or drive or take an Uber or something like that. So insofar as how competitive dynamics play out between firms, nationwide industry NAICS codes are pretty tough to draw conclusions from in sense of competitive dynamics. I'll give you another example, which in some respects is interesting, because you can actually find that increased competition and entry can look like increased concentration if you aggregate up high enough. So let's hypothetically take a company that decides to convince people they should buy really expensive coffee called Buckstars. And prior to the invention of Buckstars, in every city around the country, you had 10 independent coffee shops, and they each sold a certain amount of coffee. And then Buckstars comes and it opens a new store in each one of those cities. And rather than taking sales from those 10, the overall market grows. So the size of the market doubles. People discover a previously unknown desire to pay large amounts of money for expensive coffee drinks. So if you look at year one, you got a bunch of cities that each have 10 competitors in them and assume they're dividing the market evenly between them. They each have 10% share. And then in year 5, you have the same thing, except now you have 11 firms in each city. The market's twice the size, and say that that new entrant has captured most of the growth. Well, by any measure, in any one of those cities, you have a more competitive economy. You've got 11 firms fighting, and a larger market. Output has risen. But if you actually calculate HHIs, which we do, and I have math for this in the printed version of this speech, and I'm not going to attempt to do it here, not only because I'm not a mathematician, but also because suffering from a cold, I would just get it wrong. But you can show pretty easily that the exact situation that I just outlined would look like an increase in concentration at the national level. So there's a real measurement problem in terms of nationwide measures of concentration. And it can really confuse increased competition or increase in efficient firms, or reduce transportation costs where markets become more national with increased concentration. But that was one point that I heard a lot in the hearings, but I've also heard that this is not so clear when we talk about markups, profits, declining startups. There was a lot more concern that those were actually tracking real problems in the economy, reductions in productivity growth, reductions in innovation. I don't think, there is a lot here to sort through, and we're trying to do it. I don't think the book is written on this point yet at all, but I think it's certainly, while there is, the concentration issue itself seems not to be enough. There's a lot of other issues going on that I think the consensus that I read coming out of the hearings, well, rather than a consensus, but certainly there was much more concern as opposed to thinking that the concentration level was really the wrong measure for our purposes. In technology, I think the view was that while technology markets in general have been very dynamic, there is general concern about the durability of a few firms in some spaces, and I mentioned those earlier. And people say, well, yes, but in search and whatnot, there was vigorous competition, and in social networking, there was vigorous competition. But the point that was made at a number of the hearings was Google versus Yahoo was a long time ago. Facebook versus MySpace was a long time ago. Who are the challengers today? It's not so clear that those challengers have arisen. And so while I would not say there was a consensus that there absolutely is a problem, there certainly was a lot of concern expressed at the hearings that there could really be a problem in the technology space. So the next question was, is it antitrust fault? And by the way, just for context, so I spoke at a conference in Europe last week on similar issues. And one of the things that I noted that was really interesting to me about the conference is this question, was it antitrust fault, was largely skipped. The discussion was one, are there big companies that have been durably large for a long time? Then two, if the answer to that is yes, the question is, what should we do about it? And the question of why did that happen and did that have anything to do with competition policy was at best an afterthought. And I just thought it was an interesting question because in the US, or an interesting approach, because in the US, this is actually a foundational point. As I said earlier, antitrust isn't a general panacea to all social problems. In the US, antitrust is law enforcement and not industrial policy. And so we have to look for specific things. And what we look for specifically are, one, mergers that create market power or that enable coordination, as we talked about in the Tronox case recently, which was far from high technology, but still interesting in terms of theories. But mergers of incumbents that create market power are not really the issue, at least that I see or that people have talked about in the hearings with the technology economy. The tech firms, by and large, didn't get big by buying big incumbent rivals. You didn't have the equivalent of a Sprint T-Mobile in the tech space. Google did not buy Yahoo. Facebook did not buy MySpace. Now, there's a subspecies of merger policy which has gotten a lot of attention, and this has to do with the acquisition of nascent competitors. And it's a point that's that has not only gotten a lot of attention at the hearings, but in much of the other discussion in this area. And the point made there is Facebook didn't buy MySpace, but it bought Instagram, and it bought WhatsApp, and it bought many others. And in fact, if you look, Google has bought lots of companies, and Facebook has bought lots of companies, and there's just a tremendous ongoing sequence of acquisitions by technology firms. As I knock that over, this high-tech little name tag here. Well, y'all know who I am. I'll leave it there. So this is, I've said before, this is clearly a plausible theory of merger harm. The question is, and this is something that got a lot of attention in the hearings, I'll come back to in a minute, how do you tell the good from the bad? How do you tell when a merger of a new firm or a startup with an existing firm is actually an antitrust problem? And that actually is a very challenging question. The second thing that we look for in enforcement in the US is exclusionary or conspiratorial conduct. So we don't look for, it's not enough in the US that a firm is simply large and successful, or even that it is a monopoly and acting like one. It has to be doing something bad to have acquired that status or to be keeping it. It has to have engaged in illegal coordinated conduct, like vertical contracts, exclusive dealings that block rivals' access to inputs or outputs, unilateral conduct like the campaign Microsoft undertook against Netscape. We have to have bad conduct aimed at getting or keeping market power. And in this regard, a lot of questions have arisen at the hearings, such as, for example, is self-preference exclusionary? Does it contribute to monopoly maintenance or monopolization? And let me talk, and does it reduce welfare? Let me talk a little bit more about that. So one of the critiques that you hear a lot about technology firms, this has come up with Amazon, it's come up with Google, is you have a platform and people sell stuff over your platform or they put things up on your platform, and you also decide to offer something like that. So say Amazon, people sell shoes on Amazon, and then Amazon decides, well, I'm going to sell Amazon shoes, and they put up Amazon shoes. So the question is it anti-competitive to favor your own product on your platform? And that's a really challenging question to answer, because the fundamental question that you have to address is this likely to contribute to market power somewhere, either in the platform itself, which was the Netscape situation, or in the downstream product? And that's actually a difficult question to answer. Let me digress for 1 second on the Netscape issue just to explain why this clearly can be a problem. So this was really exactly what the Microsoft Netscape case was about, where Microsoft perceived a threat to its operating system platform monopoly from the development of this new technology. And it saw that internet browsers could support the development of an ecosystem of computer programming functions that would not need an operating system to work. And by the way, this is the world we inhabit today, right? Through the apps and the iOS or the Android ecosystems. This is the elimination of the OS monopoly. So Microsoft saw that coming, and it set about to destroy Netscape, to prevent the destruction of Microsoft's platform monopoly. So this is a perfectly plausible theory. Identifying it is a little harder. Another example of this is data accumulation. Is the accumulation and use of data by dominant firms good or bad? It could provide an insurmountable advantage. It could provide a crystal ball where a large firm in this space could be able to quickly find and kill growing competitors. On the other hand, if you have better data, you can provide better products and services. So is it a way to better serve customers and offer better products and services, or to sustain market power, or is it both, or does it depend on where you sit? Those are hard questions to answer, and that leads to the third point, and the one I'm going to wrap up on is, coming out of the hearings, what have we been hearing about what antitrust can or should do? Well, there have been a lot of proposals and ideas, and really too many for me to cover here, but here's a few points of interest, which I think I'll highlight in some respects, mainly to show how challenging this issue is. So one of the points that arose at the hearings that relates very closely to technology is concern about algorithms and artificial intelligence. And a specific concern that was raised is, could firms use algorithms, say pricing algorithms, to more effectively reach oligopoly outcomes where prices look like the price you would get under monopoly, but without colluding? So you don't actually need to get together in the back room and fix prices, because among other things, the problem with doing that is if the DOJ finds you doing that, they will come, the FBI will descend on you, and they will haul you off to jail, as well as imposing staggering fines, not just on your company, but on you personally. So that's a bad thing for most companies. They don't really want to do that if they can avoid it. On the other hand, if you can get to the same place without actually conspiring, then that might be a good thing from the perspective of a company, although a really bad one from the perspective of consumers. So a concern has been that pricing algorithms might be able to do that better than humans. You know, humans often, particularly in concentrated industries, humans do try to get to the oligopoly outcome. They look at each other's prices. They often try not to steal share from their competitors. They try to keep everything as it is, maintain the status quo, and that can produce a higher price and lower output that would otherwise exist. The fear was algorithms might do that. They might solve the problems in doing that. Well, first of all, one of the things we saw at the hearings is there's not a consensus that algorithms are even capable of doing this, that they might actually be less capable of colluding than humans, or reaching collusive outcomes than humans are. But let me leave that question to the side, because to a certain extent, that's a technological artifact that could change tomorrow. The second problem is, let's assume that perfectly rational pricing algorithms reach an oligopoly outcome because it's exactly the rational thing to do, and if you program them to do the smartest price choice every time, that's what they're going to do. What is the antitrust solution to that? Should we require firms to use algorithms that are designed to behave irrationally? That could be a bit of a problem, for example, from a corporate governance standpoint. It might be hard to explain to your board of directors why you keep pricing badly and losing share, or missing sales targets because you, in order to comply with the antitrust laws, have designed an irrational pricing structure. So this is a hard issue, and it raises, I think, very nicely the kinds of trade-offs that we have to think about. A similar example, in nascent competitors. First of all, if we want to talk about limiting or thinking differently about how we view acquisitions of nascent competitors, an important question is, do we do this across the entire economy, or do we focus on the tech economy? And if it's the latter, how do we define it? What is the tech economy? Does it include Ford and General Motors? Well, they're getting into self-driving cars, and they have lots of acquisitions in the tech space. Does it include General Electric? Does it include Boeing? All those firms, by the way, buy tons of companies. I read earlier today an article about Walmart's huge slew of acquisitions over the last 8 years, mainly in the tech and e-retail space, because Walmart is trying to position itself to compete against Amazon. Should we prohibit that? Walmart, of course, was the boogeyman of retail 10 years ago. Today, it's to some extent almost been ignored in antitrust discussion because Amazon is viewed as so much more threatening. But if we have a policy that prohibits acquisition of nascent competitors or small firms by big firms, and it's in the tech space, and Walmart, which has an online e-tail site, is buying startups in that space, are we going to treat that the same way that we would treat it by Amazon? I don't know the answer to that, but it's an interesting question. There are also effects on investment and innovation that we have to consider. And similarly, when we talk about data, there are serious questions that arise about what do you do? Let's assume that the acquisition of data by technology firms is a problem. How do we solve it? Do we require sharing? Do we reduce barriers to portability? Let's assume that we think we can solve the Facebook problem by enabling all Facebook users to port their data. And this, by the way, may be beyond the narrow reach of antitrust, but it might be a regulatory solution that could be imposed. But if you do that, bear in mind that for me to port my Facebook data means that I'm also porting all of my friends. And the question is, now I may not have a lot of friends, but you all may have a lot of friends. And so if you have a lot of friends on Facebook, there could be real privacy issues where if you decide that you're going to port to some other site, who they may not want to be associated with, can you actually move their data along with you? So these are the kinds of issues that are arising at the hearings. I think it's absolutely a fascinating time. I think they're generating a tremendous record from which we can work. my belief is that, well, I know for certain that we are going to come out with a whole series of reports that are going to make recommendations based on what we've heard. My belief is that we are going to do some things, certainly in some of these areas, and in some respects we already are. But I think the story is still to be written in many cases. So I wanted to give to you today kind of a snapshot of where we are, and then the message to stay tuned, and we'll see, I think, a lot more come springtime, and then maybe early in the summer of next year. So that's all I got. Thank you very much. I really appreciate it. I could do a question or two if anybody's interested.
Question or two from the audience.
We heard from Commissioner Chopra about violating consent decrees and his interest in making sure those aren't just suggestions and that companies take those seriously. I mean, there are a couple of those that are pretty big that are, it's been disclosed, there are investigations. Are you in agreement, or, is there a consensus on that, on Commissioner Chopra's point that those consent violations need to be enforced more toughly, more aggressively?
Absolutely. I mean, I don't want to criticize, and I don't have a basis to criticize past enforcement. I've actually been on the receiving end of violation of consent decree enforcement from a violation that I was not counsel to the client at the time, but I was hired subsequently, and the FTC, I will tell you, I thought was pretty strict and imposed a pretty significant fine. So I think there's been a lot of enforcement in this area, but I also think it would be fair to say statutorily we have an upper limit on what we can do, but that upper limit is fairly high in some respects. It's a lot lower than, say, the statutory limit in Europe. But there are some guidelines out there, and there's a body of case law on how you do this and what the parameters are. And I think there's a general consensus inside the agency that we need to make sure that people understand that consent decrees, or for that matter, any decrees, whether litigated or consent, are things that need to be taken very seriously, and that we are going to take very seriously and pursue vigorously any violation of those.
Hi. Commissioner Chopra was suggesting that forcing executive dismissals might be a non-monetary way to deter bad behavior. What are your thoughts on that?
I don't think the Bureau of Competition has a view on that. I think when you get into the questions of what our statutory parameters are for the kinds of penalties that we can impose, I'd have to actually look and see if that's available to us. I do think that when companies look at the consequences of violating orders, then obviously that can have implications for the executives that were involved. So some of that may occur through corporate self-governance on its own, but in terms of the kinds of penalties that we impose and the remedies that we seek, those are dictated by our statutory authorization, and I frankly haven't looked closely enough at that to know to what extent that's possible. Maybe one more, if there's anybody? I saw her first.
I was wondering, what's your opinion about tech platforms such as, for example, Uber, when they, and to some extent possibly Amazon Marketplace, maybe I shouldn't name specific companies, but more generally a tech platform, if it's involved in setting prices for a commodity that it doesn't sell, should that be something that the FTC should look at?
Well, I don't want to, let me be clear that I'm not commenting on any specific investigation. But I think that raises a really interesting question, which is, if you have let's suppose that I have a marketplace of some sort, I'll just use that as an abstract for a platform, and I set a price for transactions in that marketplace. So you could do that in a couple different ways. One is you could say, this is completely unilateral, right? I'm just saying, hey, look, if you want to buy X product at this price, I will connect buyers and sellers. So anybody who wants to come and sell antiques in my antique shop at $5, $10, $15 price points, you can come in and set up your $5, $10, $15 booth. And people who want to come and buy antiques for $5, $10, or $15 can come here, and they'll know that's what they're going to get. Now, no one has to do that, right? If you want to go and sell your antique for $75 or $1, you can go do that on your own. I'm just setting up a place which is very efficient because everybody will know I can sell for 5, 10, or 15. I can buy for 5, 10, or 15. The other way you could view it is you're facilitating a cartel, right? I'm a platform of some kind, and what I really want to do is I want to get sellers together. I want to stabilize the price. I want to set that price. And I don't think the answer to that is obvious. I think you would want to look very hard at what are the incentives. In other words, does the platform that's enabling that conduct have an incentive to fix prices? Because typically that would mean that what you want to do is set the price at a super competitive level. You're going to suppress output some, and presumably you're internalizing some portion of the resulting profit. Okay, so do I have an incentive to do that? Or do I actually have an incentive to set up something which is going to reduce transactions costs and facilitate more efficient contracting? If you have the latter incentive, I think the cartel explanation is less likely. If you have the former incentive, then I think the cartel explanation is more likely. But I don't think it's a question that you can answer in the abstract and just say, for all platforms the answer is X, or for all platforms the answer is Y. So with that, thank you again. I really appreciate it, and it's been a pleasure.